So today's material is about using people in ads. Most of our class time is going to be spent on the interests of the person who appears in the ad or whose identity is in some way used for the ad, but we are also going to deal with some consumer protection issues from endorsements, and I'm going to briefly talk about those. Consider this excerpt from the FTC guides. A positive review by a magazine without compensation is not an ad. However, the FTC takes the position that if the producer then wants to pay to disseminate the review, it becomes a form of advertising. Two significant consequences follow. First, a substantiation obligation. If the review says stuff that the advertiser could not itself substantiate, they shouldn't be disseminating the review. Second, there's now a disclosure obligation if it's not obviously advertising. But consider the question, if the content was originally created independently, does the justification for mandating disclosure of sponsorship still apply? Now, we might defend this on the ground that otherwise it will be too easily gamed. Advertisers will too easily pretend that the content was created completely independently and just later adopted sort of fortuitously. But consider how consistent with the First Amendment doctrine that we've looked at that justification is. Also, it's just not as clear that the producer should have to disclose, we got this into your range of vision because we have an economic interest in having you buy the product that's being reviewed, versus, we paid for this review to happen in the first place. Failure to disclose in the first case is less obviously likely to harm the consumer. But nonetheless, the FTC's official position is these endorsement guides are our interpretation of Section 5. So we only require disclosure when failure to disclose is materially misleading to consumers. We just think that a failure to disclose the sponsorship would be materially misleading. This leads into Eric Goldman's critiques of disclosure requirements. The government is, in some sense, telling you to care here. And there may be some risk of information overload. Although, frankly, compliance with this sort of thing is so low, it's not obvious that we're anywhere near the overload situation. The FTC gives another example from video games. The FTC says basically that if the characters are wearing branded clothes without factual claims being made, then disclosure of payments is probably unnecessary, because whether the branded products appear in the game because of payment by the sponsoring advertiser or because of the video game developer's creative judgment is not likely to be material to consumers. Consider whether you think that's true. In addition, the FTC then acted against failure to disclose that these influencers were paid to promote this dress. So is that consistent? The FTC identified 3 false and misleading claims. Lord & Taylor falsely represented that the 50 different posts on Instagram and captions reflected the independent statements of impartial fashion influencers. They failed to disclose the material fact that the influencers were the company's paid endorsers. That's the second material misrepresentation. And third, there was a related article in Nylon magazine, and Nylon falsely represented that Nylon, Lord & Taylor falsely represented that Nylon and Instagram posts reflected Nylon's independent opinion about the Design Lab line when they were really paid ads. So you can consider whether there's a distinction from this versus the video game case, and whether these are the claims against Lord & Taylor for Nylon, the online magazine, were equally strong as the claims related to the influencers. I also want to briefly mention, how do you frame proper disclosures for endorsers once you've decided disclosure is necessary? So the FTC has helpfully provided guidance on this, although it's already looking a little outdated. But this tweet, if Julie Stars is a paid endorser for Fataway, this tweet requires 2 disclosures. First, that she is a paid endorser, and second, it requires the substantiation related disclosure. How much weight can consumers who use Fataway can generally expect to lose in the depicted circumstances? And if that's less than 30 pounds in 6 weeks, then this ad will fail on both counts. Even if the link in the message leads directly to these disclosures on the FatAway website, these disclosures are not adequate if consumers can purchase FatAway by any means other than by clicking on the link. So if it's sold at a brick and mortar store, or if it's sold at a separate website, they might not click through to the FatAway website on this tweet, and they wouldn't see these disclosures. Likewise, the FTC doesn't think that any of these are okay. So the putting disclose in the URL does not help. Spawn is not sufficient disclosure. It's not a well understood term for saying I'm a paid endorser. And the other thing actually about the middle one is putting a hashtag after a URL may be confusing in the FTC's opinion. The UK Advertising Standards Authority has also rejected SP hashtag as insufficient, so it didn't like this one. Likewise, to the ASA, recommends and with were not sufficient, because with could indicate to some consumers that the brand had been involved with the process, but it didn't clearly indicate that the post itself was a marketing communication from the brand, as opposed to material that the creator had editorial control over. The ASA has the same objection to sponsored by and brought to you by. Consumers should be aware that that's advertising if the sponsor has editorial control. There seems to be some convergence on hashtag ad as okay. The FTC has specifically said this one's okay as long as consumers understand it's an ad. In fact, you don't need the hashtag if they already understand this. This isn't just a Twitter and Instagram thing. So one of the issues here with bloggers in particular is what if they are given free product? So this is an example where the last line says, Paint World, by the way, Paint World gave me the paint to try out, but so terrific, I'll buy it myself this time. The FTC considers that insufficient. It's in the last line, it's not highlighted. It could easily be missed after you read the review. So this is the kind of thing the FTC will not approve of. So that's our introduction, and we'll talk more about publicity and endorsement in class. Thank you.